typically in housing societies, there are many types of worker staff that are employed. For example, watchmen हो गए, gardeners हो गए, sweeper, office staff वगैरह हो गए. And sometimes they work for many years without any employment benefits as available in other private and public sector business houses. However, in a particular judgment dated June 2018, Mumbai HC, Mumbai High Court, decided that labor laws are not applicable to housing societies since housing societies are not classified as an industry. In today's topic, our speaker will briefly explain about such finer points. On behalf of all the participants, I invite today's speaker, Advocate Jagdish Advani. Jagdish Advani Sahab is from Mumbai and deals in all types of labor court matters and other matters too. He shall share his knowledge on various possibilities and legal remedies on today's topic, which is cooperative housing society, applicability of labor laws, provident fund, ESIC, gratuity, bonus, etc. On behalf of all the participants, we welcome Jagdish sir and request him to share his knowledge with all of us. Over to you, Mr. Jagdish. Thank you, sir.
Thank you, Mr. Hemant. Now, as you have introduced me to everybody, I am Jagdish Advani. I specialize on labor laws, and most of my clients generally, I represent only employers, not the employees. Now, when I had the occasion of interacting with Mr. Hemant regarding our society issue, because he is helping us out with many issues related to our society also. Now, he just requested me whether I could participate in this forum and share my knowledge or share the information with all of you all. So, I said that this is a good opportunity to let a lot of people know about the various aspects which we have to keep in mind when we are considering cooperative societies. Now, as all of us are aware, that cooperative society, what exactly is a cooperative society? A cooperative society is an association of people which have come together in a particular premises, and they are forming a committee to provide beneficial services to the members. Now, the services which are provided, such as collection of municipal taxes, water taxes, property taxes, any other government funds, government dues which are there, all those things, instead of the individual members making payment of the same to the authorities, the society is formed. It collects all the funds on behalf of the members on the basis of the bifurcation that is already decided by the municipal authorities, and it will depend on the area of your flat, that how much would be your contribution to the amount that is payable for a particular tax which is payable. Now, as we are aware, now in this forum we are specifically dealing only with cooperative housing societies, because there are different types of societies which are there, which are registered under the Maharashtra Cooperative Societies Act 1960. But since we are dealing specifically only with cooperative societies here, I would like to first give a basic gist. Now, Mr. Hemant also advised me that I should not go too much into technicalities and I should try to keep it as simple as possible. So, without having to refer to the provisions of law which are there, but keeping into mind what provisions are applicable, I would just like to bring to your knowledge a few things which are there. Now, as you all are aware, that the various labor laws which are there, such as the Employees State Insurance Act, the Provident Fund Act, Payment of Bonus Act, Payment of Gratuity Act, they apply to all those establishments where there are employees who are employed, and the employees are provided certain benefits under those laws which are applicable to those establishments. Now, as you all are aware, the Employee State Insurance Act is an act which provides for benefit to the employees in case of death or disablement, or if there is any injury to the family members, or if there is any hospitalization or anything, then the ESI authorities provide benefit under the Employee State Insurance Act to such employees. Similarly, under the provisions of the Employees Provident Fund Act, there are benefits which are given to the employee whereby a particular amount of contribution is deducted from the employee share and from the employer share, and it is deposited with the authorities which collect a particular amount of interest over a period of time. And when the employee retires or leaves the organization, at that point of time, those amounts are paid to that employee. It is like a retirement benefit which an employee receives. Now, taking into consideration the various aspects which are there, now as Hemant sir said rightly, that the Bombay High Court has held this decision was in the matter of Arihant Siddhi Cooperative Housing Society, wherein a watchman had approached the labor court and claimed reinstatement with back wages, and there were certain commercial aspects to it, whereby the society was giving the premises of the society or a part of the premises of the society for putting up of neon boards and signs for which they were collecting money from the members, and therefore the contention of the workman who was a watchman was that this society is having a commercial activity, and therefore it should be treated as an industry, and therefore the provisions of the labor laws should be made applicable to it. The labor court accepted that contention, and therefore it held in favor of the watchman and directed the society to reinstate and pay back wages to the employee. Now, when the society challenged this before the High Court analyzed all the issues, and then it came to the conclusion that just because the society is doing a commercial activity of letting out its premises for a part of the time, it would not fall under the definition of an industry for the provisions of the Industrial Disputes Act to apply to the society. Therefore, the Bombay High Court rejected the claim of the workmen, and it reversed the order of the labor court. So, as we are aware that law is something which is a very, I would say, a confused field, sometimes even for lawyers, because what the law states in the book is something, but when the interpretation of that comes, we have different judges giving different interpretations, unless the matter goes to the Supreme Court and it is finally decided by the Supreme Court, that it becomes binding on all the courts, the subordinate courts, which include the various high courts and the district courts which are there. Now, coming back to our subject, the cooperative societies, majority of the cooperative societies are only functioning as a mediary between the members and the government authorities in respect of the statutory compliances related to the society. Now, whether such an activity can be concluded to be an industry or not, that had been a very sort of unsure position as far as the societies were concerned. But then this matter was put to rest by the decision of the Honorable Bombay High Court. Now, coming to the provisions of the various acts which apply. Now, the ESI Act, which is there, which is the Employee State Insurance Act, which was formulated in 1948. Now, earlier the said act said that the same would apply to establishments wherein 20 or more employees were working. But the definition of establishment was not provided. And therefore, various authorities, the ESI courts and the various high courts, they gave conflicting judgments as far as the applicability of the acts were there. But now, since the position has been cleared, there was a decision which was passed in the matter of Tulsiani Chambers premises against the regional director of ESI, which again confirmed the fact that if a society is not carrying out any commercial activity or is not only a purely commercial organization, till that time the provisions of the various labor laws which are there, they would not apply to a cooperative housing society. But in spite of all those things, now as we are aware that now payment of bonus act, generally payment of bonus act also applies to an industry or an establishment where commercial activity is carried out for the satisfaction of human wants with the cooperation of the employees. Now today in a cooperative society, I'm sure all of us who are members of cooperative societies, we are aware that we are employing, like how Hemant sir said, we are having watchmen, we are having housekeeping staff, we are having managers, we are having other service providers who are there, who are working whole time for the benefit of the society, and they are available and they are devoting their full time for the benefit of the society. Now, if a person is working with you for 12 months of the year, exclusively for you, then in all fairness, that employee becomes entitled to receive certain benefits, although the same may not be statutorily applicable to them. So many of us, I'm sure all the societies which are there, they generally always make payment of bonus to their employees, which is generally one salary at the time of Diwali they give. And that is just given to show or express their gratitude to the employees for providing selfless and loyal services to the society for the period of the 12 months. Now, similarly, the Payment of Gratuity Act, which is there, again, the Payment of Gratuity Act applies to establishments which are having 10 or more employees, and it is payable to employees who have completed minimum 5 years of service with a particular organization. But this 5-year qualification period is not required as far as the death of an employee is concerned. So even if an employee has worked with you for a period of maybe 2 years or 3 years, and if something happens and unfortunately the employee dies, then at that point of time, the establishment is supposed to make payment of gratuity, which is calculated at the rate of 15 days of wages per year of service on the basic and the DA, which is paid to the employees. Now, this again is a benefit which is given to an employee. Now, we have to understand one thing, that majority of the labor laws which are there, they are all social welfare legislations. That means the prime intention of the legislature was to provide social benefits to the employees who were supposed to be the oppressed class or the suppressed class with having no means to ensure the safety and upkeep of their families. Now, for example, many of us who have got various sources of income, the employee's only source of income is from his employer. Now, if he doesn't come to the employer for anything, where does he go to? Today, he also has got a family which he has to take care of. He also has got expenses for which he has to provide for. And nowadays, we are aware medical expenses are something which are very, you can say, expensive, not only for workers, even for many of us. God forbid if we have to face any major expenses. Now the expenses, they start off only into lakhs. Earlier there were times when there were a few hundreds or a few thousand spent, but nowadays it is running into lakhs. So now in such scenarios, where does the poor employee go? Now, as far as the labor laws are concerned, as I have said, the provisions of the Act only apply to establishments which fall under the definition of an industry. And this decision is based on the decision which was decided almost about 70 years ago in the matter of Bangalore Water Works. I think this was in the around 1960s or 65 somewhere, where this decision was there, where it was decided that what exactly is the industry. Even today, the Supreme Court relies on the said judgment to analyze whether any establishment falls under the definition of an industry or not, because all the details pertaining to the industry are mentioned specifically in that judgment. Now, what is the crux of the matter here is that because the labor laws are not applicable to cooperative housing societies, because we are not an industry and therefore we are not amenable under the labor laws, there are various cooperative societies, like for example our society. We give bonus. We are having in one society where I am staying, there we are having about 4 or 5 employees, and there are another say 3, 4 watchmen, so around 7, 8, 9 employees. In another society where I have got my office, we have got around 3, 4 employees. So we in any case do not fall under the provisions or ambit of the labor laws, but still we are giving benefits to the employee as far as either the bonus is concerned, or when they are leaving the services of the society, we consider some payment which is classified as ex gratia payment, which we give to that particular employee because of long meritorious service with the society. Now today we are aware, what do you mean by a watchman? A watchman is a person who is supposed to guard the premises and guard the members and their flats and their families against intruders or robbers who would try to come into the establishment and try to take something away from the premises of the members. Now, when such a person is actually putting his life at risk for you, whether we should or we should not consider certain benefits to him, that is a question that each individual society and each individual member has to answer. But in my opinion, it so happens that we should always try to ensure that the employees are given certain benefits which may not be statutorily applicable to the society, in order to ensure the protection of the employee and his family. Like for example, in our society, we have taken out an insurance policy which will cover the society members, the society employees, against any accident or anything which happens to them while they are on duty. So many of the companies also, where the provisions of the ESI Act are not applicable, they take out certain policies like the Mediclaim policy or the life insurance policy, which they give as an additional benefit to the employees. So, in my opinion, the societies also should consider making such a provision for their employees, although the provisions of various labor laws are not applicable to the establishment which is under cooperative housing societies. So, therefore, what happens is that the employees are left without any backing or any support if they are working for cooperative societies, in view of the now judgment of the Bombay High Court also, which I'm sure the Supreme Court also would confirm, because the Supreme Court also has to interpret the law. And the law is already clearly defined as to what is an industry and what is not an industry. So therefore, the provisions of the labor laws. Now, when Mr. Hemant told me the other day, I was a little confused as to what knowledge should I share with you, because the summary of the whole thing is that if a cooperative housing society is not an industry, then the provisions of the labor laws do not apply to the society. Now, that would have been a one-line summary which I could have finished in 2 minutes probably. Mr. Hemant, am I right? So now from that point of view, it is basically for all of us to be aware about what the laws are and about what we need to do to not only safeguard our interests but to ensure that the employees also are benefited from the society because they are providing selfless services to the society. Now, one aspect which has to be considered, that although the labor laws do not apply to the establishments of societies, but in case if any employee meets with an accident or if unfortunately he dies, then the employee can always approach the civil court or the motor accident tribunal or any other such forum which is there for claiming compensation against the society, because what has happened while he was on duty. So even if by filing a civil suit, if he can claim compensation against the society, and assuming that the society is required to pay an amount which runs into lakhs of rupees, it is always beneficial to take out a insurance policy first, primarily to protect the interest of the society against any liability which could come onto it in terms of any accident which takes place in either related to the employees of the society or related to any other outsider. Like today, when we go to various other buildings, also, if God forbid, if we meet with an accident and if we are injured in that society for which we require to be hospitalized or we have to spend a lot of money, actually, where are you going to claim it from? We are going to claim it from the society that I was in your premises and because of your premises, I got injured. So, in order to safeguard the interest of the society, the principal office bearers and the managing committee members are required to bear this fact in mind that it should always ensure the primary protection of the society and the members. Today, if the society is saddled with any liability which is payable to a person who is an employee of the society or an outsider, ultimately who's paying the money? It is not the managing committee which is paying the money. Although the money is going from the society's account, the contribution for that is given by each and every member. So every member becomes liable for an amount which is payable or any liability which accrues on the society for any reasons whatsoever. So it is always beneficial that the society should consider safeguarding its interest in terms of the unforeseen circumstances which it might be required to face at a time where it can protect itself by ensuring that they take out a proper insurance policy. Now, as far as the applicability of the acts are concerned, as I said, that because the acts are not applicable. Now, I do not want to unnecessarily burden all my friends who are here with the nitty-gritties of how the acts are applicable to various establishments and what are the benefits which are there under those acts for establishments which are covered under them. Because here, this is not the forum where we need to discuss the various acts which are there, because there are labor acts which are running. I have got a list of around 60 bare acts which are applicable to industries. Now, we cannot discuss all those acts which are there in the context of a cooperative housing society. But here, only one thing that I would like to point out is, although it is not related to my field of operation, it is pertaining to profession tax. Now, profession tax is, as you all are aware, it is a tax which is only applicable to the state of Maharashtra. It is not applicable to the other states unless there are specific enactments made by those states pertaining to the profession tax. Now, here the Maharashtra state tax on professions and other vocations, it lays down that the profession tax is payable in respect of employees that are drawing salary exceeding rupees 7,500. So if societies are having employees where they are paying the salary below 7,500, that employee is not covered under profession tax. But if the employee is drawing salary from 7,500 up to rupees 10,000, then the society is required to be registered under the Profession Tax Act as an employer, and similarly the employee also has to get a number, a profession tax number, which under which the payment is made to the profession tax authority. Now, if an employee is drawing salary from 7,500 up to 10,000, the amount of contribution that is payable is rupees 175 every month. That is payable to the government authorities, and if the salary is beyond 10,000 up to any limit, then the amount which is payable is rupees 200 per month, except for the month of February, which is payable in March. The salary for February, which is payable in March, for which the contribution has to be 300 rupees. In case of lady employees, the benefit is the tax is payable only if she is drawing a salary exceeding rupees 10,000. So if you have got lady employees who are below 10,000, then you are not liable to pay any profession tax for them. But beyond 10,000, the same slab would apply, whereby you are required to pay 200 every month and 300 for February, payable in March. Now, this is the only, you could say, act which applies to cooperative societies, and in this context also there in this context also, now there the profession tax authorities, they are initiating proceedings against various societies, and they can recover if suppose if a society is amenable under the Profession Tax Act and has not been registered and has not been deducting and paying the amount of profession tax. Because see, a profession tax is what? It is not payable by the society. It is payable by the employee to the authorities. So the society is just an intermediary where they are deducting it from the salary payable to an employee and they are passing it on to the government authorities. So it is not a liability of the society. But in case if the society has not gotten itself registered and if they have not deducted and nor paid, then the penalties are pretty high. The authorities can recover the whole amount along with hefty penalties and fines, which then the society would be required to bear, because many a time that happens in societies that an employee works for a particular period of time and then goes away. So payments are made by check, payments are made by NEFT now, so it cannot be denied that the employee was working for us. So the details of that are obtained by the authorities from the society records, and the calculations are made whereby the society is saddled with the liability. So from day one, the society is required to be covered under the Profession Tax Act, and they are supposed to comply with the provisions which are there. Mr. Hemant, in
Yes,
this
sir.
context,
Yes, sir.
now, as I have said, that the provisions of the various labor laws do not apply. I have also gone a little out of context and given my opinion as to what societies should do in order to protect their interest also. So I hope that all the people who are here must have understood the concept of what I am trying to get at in terms of, because my interest also is in the interest of the society. I am trying to ensure that the society is protected. The society and its members are protected from all liabilities which it could face, in spite of the fact that certain acts do not apply statutorily to the establishment of a cooperative housing society. Now, I think a few members have raised certain questions here by messages. Uh, Mr. Vikrant Jindal, he has a question that should a member in his individual capacity changing water pipeline outside his flat, which is on top floor, does insurance can be taken out for just a day work because accident can take place at any time? Yes, it is something which has to be done, but generally the work which is an outside work is always the work of the society. If it is the replacement of a pipe which has to be done from outside, then that work is the work of the society. And normally, in especially high-rise towers and everything, the society has got a particular fixed worker who does the job for the society and for which the society is making payment to the said plumber, who will be exclusively available for the work of the society. In case if the society does not have any work, then he is free to take up employment elsewhere also and do work on contractual basis. But whenever he is called by the society, he has to immediately revert back to the society and see that the job is done. That is for which he is paid a particular amount by way of fixed remuneration every month. In addition to that, whatever work has to be done has to be paid by either the individual member or by the society, depending on what it is. So, Mr. Jindal, I think it is always better if you are doing the work on a personal basis, then it is always better to have a policy taken out, even if for one day, or if you feel that it is too much of an exercise of going through the process of taking out an insurance policy just for a day, then you have to ensure that the work is done by the concerned person through the society and not you, and your society has a general insurance policy in place, because that is more appropriate, because everyone who's a member, if he is doing a work for a day or maybe 2 days, they cannot practically go and take out a policy, and by the time the process of the policy is done, the work is already done. So it really doesn't make sense to try and go in for a policy whereby by the time the policy comes, the work has been finished. Now, Mr. Jindal's query is also related to the profession tax again. Between 7,500 to 10,000, the slab is 175 rupees per month. And above 10,000, it is 200 rupees per month, except for the month of February, which is payable in March, which is 300. So the total amount of contribution is maximum of 2,500 for an employee whose salary is 10,000 and above. Then if his salary is even 1 lakh rupees, still the amount that he has to pay is only 2,500. So now if any other member has any queries relating to what I have just stated, then Mr. Hemant, I think they should be asked to raise those queries.
So there was an incident about 2 3 years back in either Kalyan or Thane, wherein few workers, contractor workers, were called in, and they were supposed to be cleaning the main WC tank. They entered the WC tank, and somehow they could not come out. They suffocated to death. Police were called in. They were arrested. Now, in this case, the labor laws are not going to apply because of the contractual level. Okay, fine. Criminal laws will definitely apply because ultimately the police arrested the office bearers, chiefly the chairman and secretary, and they are still under prosecution.
Hmm. Right.
So even if labor laws do not apply, criminal laws will definitely apply. That's what is my feeling. I request your comment on this thing, please.
That is why I had recommended that there should be a policy taken out by the society to cover all such liabilities, and still at the same time the office bearers have to act in a bona fide manner, and they have to be able to establish that whatever was done was not due to their negligence. Today, if anything happens in a society, the persons who are responsible are the office bearers, the managing committee members. Now, we are aware that, especially in high rise towers and all, there is a requirement from the fire department that the fire system has to be in place and it has to be proper and operational. Many societies don't have that. They don't have the connections to the main fire source, so that in case of any fire or something, they don't have any fire extinguishers, no fire alarms, nothing. Now in such a case, even if there is a fire from the member's house, which spreads to the other parts of the building, ultimately the case of negligence would fall on the society members and the managing committee members. Primarily so on the managing committee members, because they are the people who are responsible for ensuring that such incidents do not take place. Now, as you said, Mr. Hemant, the provisions of the labor laws are not applicable, but criminal law is applicable to everyone. Nobody is above the law. Criminal law applies to everybody, and therefore, if there is any negligence on the part of the society, now I don't know whether you all are aware. I think I forget the name of the society, but around 2 years ago, 3 years ago, there was a society in Khar on the 17th road which collapsed. The whole building collapsed. I mean, a part of the building collapsed, and then the rest of the building was declared as very dangerous for anybody to be staying there. And I remember one little girl, she lost her life, one 12-year-old girl, because she was in the hall and that hall part collapsed and the full building went down. There, the society committee members were prosecuted because what had happened was actually the condition of the building was very dilapidated, and they had appointed a contractor to do the work. Now, the employees of the contractor, maybe they were not aware about the exact structural stability of the building, and there was no structural engineer on site. What these people did was they used a cutting tool for cutting a part of the pillar, and that pillar, which was on which the support was based, that broke and the whole thing came down. So it was during the course of the work that was being done by the contractor's employees in repairing the building. So, in spite of the fact that the managing committee members mentioned to the authorities that we are ensuring that we are getting the work done. Now, if something like this happens, we cannot do anything. But still, the matter went to the police authorities, and then I believe that due to the help of the local corporator and the influence part. The matter was, they took the statements of the managing committee members, and then ultimately they decided not to take any action. But the present status, I would not be able to comment right now on that as to what exactly is the present position. But yes, criminal laws do apply as far as the societies are concerned, and that is why, in order to ensure that the managing committee members do not come into trouble, it is very, very practical for them to ensure that they comply with all the laws and the safety precautions which are necessary for the protection of the property of the society, as well as ensure that no injury is caused to either members of the society or any outsiders or the workers who are working there.
Sir, a technical question comes in, like high courts have said that labor laws are not applicable to housing societies. Okay. Now, if so, I wish to employ child labor. I wish to employ some labor below the status of what is called as minimum wages. मुझे वो सिक्योरिटी को अप्लाई करना है, एंगेज करना है, लेकिन मुझे उसे सिर्फ 5,000 रुपये देना है.
हाँ.
उसके 12 साल के बच्चे को हम एम्प्लॉय करते हैं किसी कारण, छोटे मोटे ऑफिस के साफ सफाई वगैरह के लिए. अब लेबर लॉ से एप्लीकेबल नहीं है इस पे. हाउ टू गो अबाउट ऑन दिस वन? क्रिमिनल लॉस?
Child labor is a part of labor laws, and there is prohibition of employing any child labor below the age of 18 years. Between the age of 16 to 18, they are considered as adolescents, and there are certain restrictions on employing such people also. But we have seen in many societies that what happens is that we are having a maid working in the house who is doing the work of the the swabbing and the cleaning and the vessels and all that. Now she says कि साहब हमारा बच्चा है, हमारा बेटा है, बेटी है, 12 साल है, 15 साल की है, वो इधर उधर हम अकेला छोड़ के आ नहीं सकते हैं, तो आप उनको घर पे रखो काम करने के लिए, जो भी कटिंग कुटिंग का काम है, डस्टिंग का काम है, कुछ साफ सफाई करने का है, तो वो करेंगे. And on humanitarian grounds, many people do keep them. I mean, not anymore, but earlier people used to keep such small children for doing the work in their houses. But the Child Labor Act strictly prohibits such a thing. Now, in fact, there was a similar case in our building also, whereby one member had employed a girl through a agency, and the age of the girl was 17 years. But because the agency people also knew that because she was underage, below the age of 18, and there would be a problem, in the application form which they took from the girl, in that they mentioned the age as 18. So ultimately what happened, now this is in fact good thing Mr. Hemant आपने ये सवाल पूछा, ये एक ऐसा चीज है. Now there are many families like these who purposely give their daughter or child who is below the age of 18 years for employment in residential houses by claiming that the person is 18 plus and they are allowed to work. But thereafter, they or their relative will file a complaint with either some social cell or some women's cell, where they will claim that this family is employing child labor. Now, in this case also it had happened in my building that the girl was 17 years old and her sister, who was staying at some place somewhere, she complained, I think it was in Delhi or something. From there, she complained to the local women's cell there that the family is employing a child labor. Now, the police authorities had come from there. They got in touch with the local police station here, and with the help of the local police, they came and arrested the person, the member of the society, and they took him to the police station. And thereafter, there was a criminal case which was filed against him. Ultimately, they settle the matter by agreeing to pay 25,000 rupees to the child labor and put it in an FD for the benefit of that child, because they showed the police the papers and the court also that, look sir, we have got this application which shows that the age of the girl is 18. Now the error on their part was that they did not ask for any documentary evidence to show the age of the child, which is something now we should all bear in mind, that today not only do we require the proof of age, we require the proof of identity. Today we are keeping an employee in the house who's supposed to be working 24 hours with you. The main members of the family, they go out for work. What prevents a small 15-year-old child from opening the door to her relatives or her known people when there are elders in the house or there are kids in the house? So it is very much necessary that we should obtain the proof of identity of the person whom you are employing. We have heard of many incidents of employees murdering their employers and decamping with the money and the gold and the jewelry and whatever, because it is a job which nobody, it is something which nobody will come to know unless until it becomes too late. Now there are families where there are senior citizens who are staying, their children are abroad, they employ some maid or some child who's working there, and they say that okay, now our parents are safe. It's not so. Without having any proof of identity, in fact, even after having proof of identity, sometimes it becomes very difficult, because these people, they will produce an Aadhaar card or a PAN card which will show a particular address, but they don't live at that address. That address does not exist. So it is very much necessary to ensure that not only do we get the proof of identity, but we also register the servant at the local police station, and the police does the verification then about everything, and their photographs and their signatures and their thumb impressions all are taken by the police authorities and kept it in the records, so that if anything happens, then they are in a position to trace those employees at any point of time.
सर व्हाट अबाउट मिनिमम वेजेस? लेबर लॉ
What about
एप्लीकेबल नहीं है, लेबर लॉ एप्लीकेबल नहीं है सोसाइटी में, लेकिन
हाँ,
बट स्टिल वॉचमैन आर एम्प्लॉयड अंडर मिनिमम वेज कैटेगरी.
नहीं नहीं ऐसा नहीं, एज आई सेड नो, because of the fact that labor laws are not applicable to the cooperative housing societies, there are a lot of societies which do not comply with the minimum wages. Now, like you said about a watchman, now normally if we are employing a watchman through a contractor in a company or in any organization which is an industry, we are supposed to ensure that we employ the guard through the security guard board, which
SRR
is
registered.
which is at Navi Mumbai. Now, the salary that is given to a security guard under that board is roughly in the range of around 20 to 21,000. Now, that is also only for 8 hours of duty. Now, majority of the societies are employing guards who are working for 12-hour shift, because it becomes more practical to have people who are working 12 hours. But in case if you employ a guard through the board, then it would mean that for that extra 4 hours of duty, instead of 21,000, you will have to give the guard a salary of 42,000 rupees, because under the labor laws, overtime is double the normal rate of wages. So if for 8 hours of duty the salary is 21,000, then for 4 hours of duty every day for the whole month would imply 8 hours salary for that day. So that becomes one more salary to that employee. How many societies would be able to afford a salary of 42,000 for a guard? And one thing is sure, that irrespective of whether you are employing a guard either through the security guard board, or you are employing the guard through any other contractor, or you are keeping the guard directly, आप सुबह को 4 साढ़े 4 बजे घर से निकलो, चाहे वो 5,000 वाला गार्ड होएगा, चाहे वो 25,000 वाला गार्ड होगा, वो सोया हुआ मिलेगा.
Correct.
So that is something, and now because of that, there are societies which are paying salary which are very low because there is no governance in respect of the minimum wages which are applicable to other establishments. So there are societies like, for example, in our society, we are paying a salary of around 12 to 14,000 rupees for 12 hours of duty. So this is something which is common to, and I am sure that as far as our society is concerned, we are paying a little on the higher side also. There are many societies which I am aware about which are paying salary for 12 hours of duty, which is ranging from around 5,000 to 7,500. And the advantage being sometimes is that all these people who are working as security guards are from the northern side, either UP or Bihar or whatever. When they come to Bombay, they do not have a place to stay. The society provides them with the premise to stay and to cook their food and everything. So it becomes very cheap for the guard to work for a lower salary, because otherwise, if he's staying outside anywhere, he would have to spend 5-10,000 rupees on the staying, another 5-10,000 for the food that he has to, either eat outside or whatever. So even though he's working on a salary of around 5-7,000, he saves around 10-15,000 by being allowed to be staying on the premises. So because of that, they do not mind having to work on a lesser salary, in spite of the fact that if they go elsewhere, maybe instead of say that 7,000, they will get 10,000. But then in that 10,000, they'll have to stay in their own house. They will not be permitted to stay in the society premises.
Sir, a typical another question arises is, since labor laws are not applicable to housing societies,
Right?
obviously maternity leave to female employees are also not going to be entertained.
Not applicable. Correct.
And at that moment, a female employee has to go on leave. तो सोसाइटी से कि भाई काम नहीं किया, ड्यूटी पे एब्सेंट थे 3 महीने, पगार पानी नहीं मिलेगा,
बराबर.
एंड सो. ऐसे सूरत में वो फीमेल एम्प्लॉयज के पास में क्रिमिनल या सिविल एक्शंस कोई बन सकता है अगेंस्ट द
नहीं नहीं
सोसाइटी?
है, क्योंकि because the laws do not apply. Under what provision are they going to go? Now, even under the labor laws, there is a principle of no work, no pay. So, if an employee has not come on duty, unless he has got leave, which he is adjusting against that absence, till that point of time, the employee is not paid salary. So, when a female employee is working and she is not covered under the provisions of the Maternity Benefit Act, then there is no question of her trying to go to any authority and trying to claim that I should be given this benefit. Otherwise, normally for establishments which are covered under the Maternity Benefit Act, the female employee gets 26 weeks of paid leave.
सर, इट इज एक्चुअली इजंट इट हाईली डिस्क्रिमिनेटरी कि आपके सोसाइटी में 25 साल एक वॉचमैन काम करता है, एक फीमेल काम करती है वो, और इतने साल काम करने के बावजूद भी 25 साल के बाद में जब वो घर जाता है वो खाली हाथ जाता है प्रैक्टिकली. बाकी सोसाइटी के मेंबर अगर कुछ उसे दे देते हैं ग्रेटिट्यूड तो बात अलग है. बट
I would beg to differ here, because now I cannot speak for everybody, but I will just speak for my society. Now we have got a security guard here, who is ours is a society which is having 150 flats. So it is a 25-story tower, and we have got around 100 cars which are there in the society. Okay. Now this gentleman is getting a salary of around 12 to 14,000 rupees from the society. In addition to that, he is getting roughly around 500 to 600 rupees per car of cleaning every month, and he is cleaning close to around, I think, 40 cars. अगर 500 रुपए के हिसाब से भी अगर आप पकड़ो 40 गाड़ी का, 20,000 रुपया उसको गाड़ी का मिलता है, प्लस जब भी हमारा जैसे बोलते हैं दिवाली का टाइम है, तो the society gives an X amount to them. In addition to that, the society also permits them to go to each flat rather, and every member will contribute whatever they want. कोई 1 रुपया देगा, कोई 10,000 रुपया देगा, जिसका जो कैपेसिटी है, जिसका जो फीलिंग है, वो शेयर करते हैं. तो ऐसे ओकेजन में भी at the time of Diwali, employees get close to around 20-25,000 each. तो at the end of the year, if you calculate, उनके पास काफ़ी सब्सटैंशियल सेविंग्स हो जाता है, जो वो जमा करके ले जा सकते हैं. तभी तो वो काम करते हैं. नहीं तो अगर उसको पता है कि भाई यहाँ पे मुझे खाली 12,000 रुपया मिल रहा है एंड आई कैन गो एंड वर्क समवेयर एल्स वेयर आई गेट 20,000, he would prefer to go there. But then he doesn't have those fringe benefits. He doesn't have 50 cars to clean. He doesn't have a place to stay. And being a person who's staying in the premises, the trust factor is always there as far as the members are concerned also. And at the same time, the members also help out a lot of, their regular staff. अभी जैसे अगर आपके घर पे कोई मेड काम कर रही है, वो बोलेगी कि साहब मेरे बच्चे का ऑपरेशन है, अभी 50,000 का खर्चा है. ओके, नाउ यू आर नॉट बाउंड टू गिव हर एनीथिंग, बट ऑन ह्यूमैनिटेरियन ग्राउंड्स यू वुड ऑल्सो से ओके, ये लो भाई 5,000 रुपया मेरी तरफ से आप ले लो, थोड़ा हेल्प हो जाएगा. इट इज जस्ट नॉर्मल that everybody tries to help out the lower strata of society and try to do or contribute whatever they can in their little ways. वैसे बोलते हैं कि charity begins at home. We are supposed to do charity. आज आप मंदिर में जाके किधर बाहर जाके आप पैसा देते हो, आपको पता नहीं है वो पैसा किधर जा रहा है, बट यहाँ पे जब भी आप अपने एम्प्लॉय को पैसे देते हो, you know it is being utilized for the benefit of the employee and his family. So it is always, these employees also, they realize कि भाई हमारे को अगर यहाँ पर रहना है, हमारे को अगर यहाँ पर बेनिफिट मिल रहा है, तो यहाँ से बाहर जाएंगे तो हमें नहीं मिलेगा. That is why they stick around, and that is why they are with the society for a longer period of time. Now, आज आपको पता है litigation is very expensive. Today, a person who does not have enough money to survive for himself and his family, or herself and her family, like you said that maternity benefit का, आज अगर कोई भी केस फाइल करने जाते हैं तो पहले लॉयर के पास जाएंगे, लॉयर बोलेगा ओके बस पहले आप इतना पैसा रखो, तो हम आपका पेपर स्टडी करेंगे, उसके बाद में हम देखेंगे क्या करना है, उसके बाद में हम डिसाइड करेंगे. So that is not something which is everybody's cup of tea, unless it becomes sponsored by somebody else due to certain agendas.
So, last question from my side before we take in our friends' questions. Typically, society, can you give some guidelines as to how to engage employees and how to terminate employees? Are there any precautions?
See, as I said, the first requirement in respect of any person that you are employing, either in your society or even in our houses or our offices or whatever, the first requirement is an application from them, supported with documentary evidence about their proof of identity. Then thereafter, if feasible, you should give an appointment letter to the employee and place on record the agreed terms and conditions, because whatever you all decide has to be mutually agreeable to both of you, and there cannot be any verbal arrangement. There has to be a written understanding between both the employer and the employee relating to the terms of employment, for which an appointment letter is necessary. And in case if there is anything which happens, like for example, an employee comes to you, साहब मुझे 10,000 रुपया लोन चाहिए, हमारे घर में समझो बच्चा बीमार है, या पिताजी का तबीयत ठीक नहीं है, हॉस्पिटल का खर्चा है, you might give it on humanitarian grounds, but many times it happens that it doesn't come back. Why it doesn't come back? Because you did not take an application from him for such a extra loan, nor did you take a receipt from him at the time of making that payment to him. And invariably, such payments are made in cash. We don't give a check to our employee कि भैया आप इसको जाके डिपॉजिट करो, बिकॉज उसका इमरजेंसी है. तो जो वो कैश में आपने दे दिया, अगर आपने उसका कोई रिटर्न कंफर्मेशन नहीं दिया तो वो जनरली नहीं आता है. So it is always better to do whatever you want to do on paper. It is always better for the interest of the employer.
Yes, sir. Sir, in MCS Act, Maharashtra Cooperative Societies Act,
Right.
earlier under Section 2, subsection 4, there was a provision of paying bonus to members and non-members who contribute their labor. In other words, staff also. अब ये बोनस का प्रोविजन था उस समय, और उस समय तक भी लेबर लॉज एप्लीकेबल थे, पर जुलाई 2019 में एमसीएस एक्ट अमेंड हुआ.
करेक्ट.
और उस समय सबसेक्शन 4 डिलीट कर दिया गया, मतलब अब वो एप्लीकेबल नहीं है, इफेक्टिव फ्रॉम जुलाई 2019 से. कैन यू कमेंट समथिंग ऑन दिस सर? पहले था, अभी नहीं है.
As I am saying that earlier there were various conflicting decisions of various courts and authorities which said that this applies or this does not apply. So the law itself was not certain about what is applicable and what is not applicable. So in order to ensure that the clarity is there for all concerned, which includes the employers as well as the employees, the amendment was carried out, and on the basis of the judgment of the Bombay High Court. Now, before this Arihan Society, there was also a judgment of the Somvihar Society, which was earlier, which was on similar lines, that the labor laws do not apply to cooperative societies because they are not an industry. So, taking into consideration the aspect, I believe that the government now has become a little more precise in trying to do away with the loopholes which were there, or the confusion which was there, and therefore there are certain things which are being very, very clearly highlighted. Now, as you are aware about the introduction of Section 154B23 regarding the estate agents not being eligible for being members of the cooperative society. Now, although the bylaws earlier used to say that no person who has got any interest in the property of the society can be a member of the managing committee. That provision was always there. But in spite of that, there were various people who were becoming members of the managing committee, becoming the principal office bearers, and then taking advantage of the same. So, in order to try and circumvent that kind of confusion and ambiguity which used to exist earlier, now the government is trying to ensure that that the clarity is given in respect of various provisions. Wherever there were ambiguities, they are trying to solve those ambiguities, and they are going to make the provisions very clear so that there is no confusion in anybody's mind.
Okay, sir. Sir, there is a question in the chat box by Mr. KD Singh.
An employee of a cooperative society abused a member in particular and all members in general. The member posted the audio on WhatsApp. Correct. Now, it does happen. Now, I'll just give you a related incident in respect of this. Now, this will be in relation to the labor laws, that today when an employee abuses an employer, that is a serious misconduct on the part of an employee. And no employer will permit such an employee to continue in the establishment, because that would be actually insulting for him before all his other employees, before whom he has been insulted and abused by a particular employee. So therefore, what happens is that such an employee is immediately thrown out of the establishment. Now, a similar case had happened. This was in respect of a establishment in Chennai, where an employee had used very foul and disgusting language against the employer, and because of that he was terminated. The Madras High Court at that point of time, now it is Chennai, but earlier the Madras High Court had awarded reinstatement with back wages to that employee, and the reasoning which was given was that, oh, this is the kind of language that the employees used, so you should not take such severe action because the employee has been abusive, because termination of services of an employee amounts to economic death, not only for him but also for his full family. So therefore, taking into consideration that aspect, such severe action should not have been taken by the employer. Now that was the kind of situation which was there even today under the labor laws. However much an employee has acted in a wrong manner, there is a particular procedure which needs to be followed. It is not that you cannot terminate the service of the employee, but you have to follow a particular procedure which is laid down as per law. Now that is as far as establishments are concerned where labor laws are applicable. Where labor laws are not applicable, like for example, the question here which is before us now, where Mr. K.D. Singh has said that the employee has acted in an abusive manner. Now the society would be fully justified in terminating his services with immediate effect. But then if the employee goes to the civil court, the question that would arise would be, have you complied with the principles of natural justice? Now, principles of natural justice is given very, very great importance in the court of law, because in any case, whatever happens is that today there are always conflicting versions of a particular issue. In my field, I have seen that there is his version and there is her version, and then there is the truth. So A's version and B's version would be totally different, and the truth would be something which is totally different. So that is why, in order to comply with the principles of natural justice, now what I would suggest to Mr. Singh is that there should be a complaint letter taken from the member concerned about the particular employee, and if the signatures of the other members who are present or who were present, whether their complaint letters also can be obtained. After that, the society should give a show cause notice to that employee, although it is not applicable under the labor laws, but they should give a show cause notice, take a written explanation from the concerned employee, and thereafter they can issue the employee with a letter of termination, which will highlight all the incidents and the facts. And thereafter, the services will be terminated. In the meanwhile, the employee can be suspended without wages with immediate effect. Because getting an employee who's abusive of a member or of the managing committee amounts to demeaning that particular member or the managing committee member. Therefore, he should not be permitted to exercise. So, Mr. Singh, I hope that this would satisfy the query that you have raised.
Yes, sir. He should be definitely satisfied. I think there is one last query. That query does not relate to today's topic. Okay. Any other friends have any other question related to today's topic? Please go ahead before we conclude today's session. We are as it is running out of time.
So I have a question, sir.
Yes, tell me.
Sir, regarding the same thing, the watchman, the employer and the employee, if the employee is using an abusive language against the member, okay, but the managing committee doesn't take any action against that employee, then in that case, what do the member do? Can the
Then the
member individually take up the complaint?
then the member has to first give a letter to the society giving the details of the incident, and if the managing committee does not take any action on the basis of that, then the only option, I'm sure Mr. Hemant would be able to guide us better, would be to approach the office of the deputy registrar with a complaint against the concerned employee as well as the managing committee member for not taking any action. Because when
Sir,
an employee is working for the society, you are not the employer. You are just a member of the society, and therefore the right to take any action always rests with the society, which is the employer. So the only thing that you can do is you can exercise your right by writing a letter to the society and a copy to the deputy registrar, and thereafter follow up the matter there. And if you feel that the incident is of such a nature or it is so grave in nature which puts you at risk in terms of that employee, it's a sort of a threat or a criminal intimidation, then you have to approach the police authorities, and thereafter the police will take appropriate action against the concerned person.
yes, sir, I agree with you. The last resort, best
Thank you,
resort
sir.
is, of course, approaching the police station for intimidation,
Yes, sir. I
abusing.
have another question, sir.
Okay. We'll
Sir,
just
can
take
I
one or two
have
last
another question,
questions.
please?
Yes, please.
Yes, sir. Regarding the insurance policy, you said
Right.
that the society should shake up the policy for the employees' benefit. Okay, in this factor,
No,
I would like to say that most societies
I,
managing committee.
I will correct you there. The society should take out the policy primarily for its benefit and its members' benefits, and also ensure that the employee is safe.
Yes, I got it. But the managing committee may not be ready to spend that money on the premium or something because the managing committee controls the fund of the society. The members may
Correct.
agree, but the managing committee might think, why get into this extra expense? Because say the ultimate power lies with the managing committee, how they spend the money. So they may
Correct.
not think that this spending of this amount is feasible or worth it. So then in that case, if a member is willing that something should be done in the interest of the employee, but if the managing committee refuses, then what source is left for the member to put up his
Then
response or
the member has to raise the issue in the AGM, because ultimately what you are asking for is for the benefit of the society as well as the managing committee members and the members. It is not your
yes,
personal benefit if you are asking for a policy. It is not for your benefit you are asking for a policy.
yes,
So you are asking for the policy for the benefit of the members as well as the managing committee members. And once the issue is taken up before the general body, and if the general body approves that yes, we have to do it, then the decision of the general body is supreme, and the managing committee is required to abide by the said decision. Then the
okay.
I will
Thank you,
managing
sir.
committee.
Thank you for this.
also like to add here for the benefit. Jagdish sir, Fatima madam is a lawyer herself.
I know. I heard that when she was there. I was hearing her.
Okay. So I would like to also add here that this insurance component covers chiefly civil liabilities. Civil liabilities against the managing committee as well as the society as an entity. अगर एक एम्प्लॉय कोई
Correct.
क्लेम फाइल करता है कोई भी टाइप का डैमेजेस वगैरह वगैरह के लिए तो द लाइबिलिटी गोस इज वेस्टेड विद द लाइबिलिटी इज लायबल फ्रॉम द सोसाइटीज फंड, सोसाइटी का नुकसान होगा. This should be a justification given to the general body by the managing committee to have this insurance component agreed upon. Insurance is not going to absolve you of criminal liability. Please remember that.
Correct. That's true.
Yes.
Okay,
Thank you,
one
sir.
last
Thank you.
question. I think Mr. Advocate Vikram Jindal wants to ask one last question and then we will conclude. Mr. Vikram, please unmute yourself and go ahead.
Yes, sir. So I put on the chat box, like if the work is given to the contractor for building and plastering, and if any accident happens, is the contractor liable or even the society is liable? Or should the society ask for an insurance whether the contractor has an insurance with his employees, those are workers who are working with? Because there's a case happened in Pune. One of the employee working while plastering the building, he had fallen down from the scaffolding on the fifth floor, and he immediately expired. And the liability came of 15 lakhs to the employee, and the judgment was that the contractor has to pay, failing which the balance the society has to pay.
Oh.
So Hemant, would you like to answer that, or should I give my comment and then you will continue with that?
If the contractor had taken out insurance, he is liable. If he was taking out a contract of such a magnitude, workers' insurance has to be taken out from the respective. There are instances of this thing, and the contractor becomes liable for everything else. However, if you can prove there is a vicarious liability of the society, then the society also becomes liable. But there are several parameters involved in this thing. It is not only an individual parameter, sir. Okay, sir. I will like to conclude this session by addressing a thanks to Advocate Jagdish Advani ji for all his knowledge sharing, that too with such a lot of patience. That was most important for our participants. कि आपने सबर से काम लेके आपने सारा कुछ एक्सप्लेन किया लोगों को. And this was a unique session because we used to always discuss things about housing societies only. Though labor laws are not related to housing societies, but some factors needed to be clarified. जैसे मैंने बताया कि अगर लेबर लॉज सोसाइटीज में एप्लीकेबल नहीं है तो क्या हम चाइल्ड लेबर रख लें या हम मिनिमम वेजेस के नीचे दे दें, या वो एम्प्लॉय जो 25 साल से काम कर रहा है फीमेल एम्प्लॉय उसको मैटरनिटी बेनिफिट्स नहीं देते. पर्सनली मुझे ऐसा बहुत दुख होता है कि अगर मेरे सोसाइटी में 25 एम्प्लॉय है और वो एक 20-25-30 साल से काम कर रहा है, वो जाने के बाद उसके हाथ में कुछ खास चीज नहीं मिलती है. तो आई पर्सनली फील कि दिस शुड बी लुक्ड एट बाय द गवर्नमेंट एंड समथिंग नीड्स टू बी डन. दैट्स व्हाट आई फील. Any comment on this particular thing, Jagdish ji?
हाँ, in fact, Mr. Hemant, जैसे मैंने बताया ना आपको कि I have already shared my opinion with all the people here, and I have given very clearly my, you can say, inclination towards having a policy in place for the benefit of the employee, so that tomorrow if the employee or any of his family members suffer any loss, or if when they leave the employment, they should have some sort of a monetary you can say compensation in hand, which they can utilize for the benefit of themselves and their family. So that being the situation, it is always left to us members of the society to consider things not only from a legal point of view, but also from a humanitarian point of view. And we should otherwise try to have systems in place whereby we say that, okay, a particular employee can be given certain benefits. Like, for example, now what we have decided is that the like security guards who are there in the building, what they do, they are also sometimes extra smart in their approach. What they do is that now bonus is given from Diwali to Diwali. अभी लास्ट दिवाली से लेके ये दिवाली तक बोनस उनको देना है, तो वो 4 महीना काम करेंगे, फिर 4 महीना गांव चले जाएंगे, फिर जब दिवाली का टाइम आएगा उसके 1 महीना पहले आके वापस ड्यूटी ज्वाइन करें. So that means when the contribution is collected from the building, even an employee who has worked for 12 months gets the same amount, whereas the employee who has worked for 6 months also gets the same amount. जिससे 7 महीने काम किया उसको भी same amount मिलता. Now we have devised a system whereby we have said that now whatever collection is there, that would be divided into number of days. And जितना एम्प्लॉई ने काम किया हुआ है उसको उतना पीरियड का ही मिलेगा. तो अगर किसी ने 6 महीने काम किए होंगे तो उसको 6 महीने का मिलेगा. किसी ने अगर 10 महीने काम किए होंगे तो 10 महीने का मिलेगा. और नेचुरली जिसने पूरा साल काम किया है उसको ज़्यादा बेनिफिट मिलेगा. सो दिस वे द पर्सन हु इज विथ यू फॉर अ लॉन्गर पीरियड ऑफ टाइम gets the benefit, gets more benefit, and he does not feel dissatisfied that I have worked for 12 months and I am getting the same amount which a person who has worked for 6 months is also getting. So this is something which this was a sort of a lacuna which was there, which we have tried to circumvent and which we will be implementing from this Diwali onwards.
Okay, sir. Before concluding, I would put up a legal point over here. Legal point. Typically, societies work on what is supposed to be no profit, no loss. जो खर्चा करना है उतना ही अमाउंट कंट्रीब्यूशन मेंबर से लेना है. और हम कई सोसाइटी के बैलेंस शीट में देखते हैं एक्सपेंडिचर में कई बार लिखते हैं बोनस 25,000 रुपया, ग्रेचुइटी 25,000 रुपया. This provision is not there at all, but yet they pay it out of the society's funds,
Existing funds.
Society's existing funds, for which there was no provision. But now this payment of bonus and gratuity by the managing committee, there is no general body involved in this thing. Maybe this audited balance sheet and the income and expenditure may be subsequently approved or sanctioned by the general body, but this payment of bonus and gratuity to the employees is a false amount. It amounts to misappropriation of funds, and that amount is supposed to be recovered back from the managing committee for paying such amounts in spite of there being no provisions in the law for payment of such things. Anyway, now with the permission of the participants, we will conclude today's seminar. I wish to thank Advocate Advani ji for giving us all the information, and also thanks all the participants for attending this informative webinar. Wishing all the participants a healthy and peaceful life forward. Thank you, everybody.